Thank you. And the final witness is Emily Dindile. Is that correct?
Hi, yes, that's right.
Policy Analyst, Innocent Project, and you're on.
Right, thanks for allowing me to testify. We actually did submit a letter for the on the record already. I just wanted to highlight a few points as well as address some of the arguments, and I'll try not to reiterate points that were already made. But you know, the Innocence Project, what we do is work to exonerate innocent people nationally using post-conviction DNA testing, as well as...
Can you move the mic closer to you?
Oh, sorry.
Okay.
Is this better?
Yeah, I think.
As well as identify the causes of wrongful convictions and work to remedy those to prevent such injustices in the future. You know, one of the causes is prosecutorial misconduct, and as we heard, it is a broad term. We use that to identify both intentional, violations of ethical rules, as well as mere error. And we heard that, you know, there are procedural processes in place, hopefully to deter this, but what those really do are they seek to provide remedies to the defendants whose rights have been violated. They're not really there to address discipline and sanctions and to deter that type of behavior. You know, the training that we heard about that's happening in the district attorney's offices is also great, and we commend it, and you know, we want that to happen in conjunction with a committee that would again issue sanctions for the bad apples, which, as our prosecutor colleagues often argue, are rare, but they also tend to be serial offenders. So the commission would serve to sanction bad actors, but also to, you know, give centralized guidelines. Right now, each of the 4 departments charged with attorney discipline have their own sets of rules and procedures, being, you know, given out of 8 different offices. And if there were to be a chilling effect, you think that it would be under the current system, where there's no notice to attorneys of what type of behavior is to be sanctioned, because there's so many different rules and procedures throughout the state. You know, behavior in one jurisdiction might be dealt with in a very different way than in another.
Have you familiarized yourself with the School for District Attorneys, NIFTY, to find out exactly what practices they teach young assistant district attorneys?
I have not, but I'm familiar enough with it, and I guess our point is that regardless of all these things that are in place and should stay in place, you know, it's clear from the exonerations that we've been working on that they're not effective. And addressing the causes of prosecutorial misconduct, you know, as well as other causes of wrongful convictions, is more than just an innocence issue, which would be enough on its own, but it's also a public safety issue. In the 341 DNA exonerations, we've been able to subsequently identify the actual perpetrator in 50% of those cases. Those perpetrators who remained at liberty while the innocent person spent an average of 14 years behind bars went on to commit more than 30 murders and more than 70 rapes. And that's just what we know of. You know, and criminalists estimate that probative DNA that can prove guilt or innocence is only available in well under 10% of all criminal cases. So our DNA exonerations represent the tip of the wrongful conviction iceberg, as well as the crimes that are committed by the true perpetrators while the innocent person was wrongfully incarcerated. So the Innocence Project did conduct an extensive review of the first 255 DNA exonerations and found that in 65 of those cases, allegations of prosecutorial misconduct were raised in either appeals or in the civil suits following exoneration. And in half of those cases, courts found either error or misconduct by prosecutors, but only found harmful error enough to overturn a conviction in 12. So you know, we feel that whether it's intentional misconduct or harmless error, it still contributes to the wrongful conviction and still needs to be addressed in some way. One of the reasons courts are reluctant to sanction or issue disciplinary action anyway is because of these other entities that technically have jurisdiction, but don't seem to be effectively addressing it. In New York, of the disciplinary claims filed between 2012 and 2014 took an average of 856 days to resolve from beginning to end. Such delays allow prosecutors who do engage in misconduct in wrongful conviction cases, to avoid sanctions for years, and in some instances permit them to engage in additional misconduct while their cases are under review. It's especially troubling because, as I said before, there are usually just a few bad actors, and those bad actors do tend to be repeat offenders. So there should be more of an urgency to address their conduct. One of the great things about the legislation in front of you is that it necessarily requires the members to have some sort of criminal expertise, as opposed to the current system, which tasks civil lawyers with review of misconduct in criminal cases. And we think that having that expertise it better positions an independent commission to distinguish between intentional misconduct, which is in violation of the ethical rules and subject to sanction, as opposed to mere error, which would not be, and at least create some sort of a common guidelines for prosecutors to follow. Parenthetically, though not in part of this legislation in front of us, we do think it's worthy of public discussion to have a similar commission for ineffective assistance of counsel claims against defense attorneys. But all in all, we just think that the call for a centralized statewide agency charged with addressing attorney discipline in New York should be established. We support that to ensure a meaningful disciplinary process and hopefully prevent future wrongful convictions.
Thank you. I'm sure everyone who spoke today wants rebuttal, surrebuttal, and whatever comes after that. However, I think we get it based upon the testimony that was given here. However, are there any questions of any of the legislators here?
I guess I could ask a very generic question that hasn't really been answered by any of the speakers that know. If there have been, for example, any other models that have been considered in other states to monitor and discipline prosecutorial conduct. Because we don't really have anything to model from. I think that the sponsors of the bill, and I'm not a sponsor of the bill, I don't think, or I'm not on the bill, it's Mr. Perry's bill, but I believe that it's modeled after the Judicial Commission because we have no other models to go by in other states.
I think for the most part that is correct.
Could you just identify yourself?
Oh, yeah, this is Steve Downs.
Okay.
Yes, Steve.
And I think that is correct. It was modeled as close as possible to the Commission on Judicial Conduct. I am aware of other states, for example, Texas, I think, that has a commission to look into wrongful prosecutions. But I'm not sure whether it's temporary or not. I don't know how it functions, which isn't exactly the same thing. In other words, that is, I think, aimed more at trying to get people out of jail. I think Alaska may, for example, be experimenting with a commission. I've heard things about that. So there are other states that are sort of exploring, but I don't know of any other state that has the kind of commission that we're proposing here. I would say that.
That's what I thought.
Thank you, John. Thank you, Bob. I believe that...
Could you identify yourself? I don't know if we have nameplates here, so... Yeah, there are nameplates there?
There are. I'm Assemblyman Nick Perry. The commission that we propose would operate or do a different work than what you just mentioned. as pertaining to the commission you cited, because this commission's intent is to provide an opportunity for, or to be a mechanism through which complaints can be made and will be addressed to the extent that we can review these complaints and hold district attorneys and ADAs accountable for misconduct. And we did, as I said earlier, take care in naming the commission, the Commission on Prosecutorial Conduct, because people will complain about conduct that is sometimes intentional, and also conduct that may appear, because of its outcome, to have been misconduct, but just happened as a matter of process, and where the accountability is necessary, but as far as discipline is concerned, it is something that would be subject to discretion in proportion to the damage that was done by the misconduct. I have questions for Mr. Schechter. Is Mr. Schechter?
There's an empty,
Schechter, there's an empty chair
there's
here.
an empty chair there. In fact, nobody sat where you sat for some reason.
I'm going to
Yes,
take the question gladly and ask Senator DeFrancisco and the others for a few moments to comment on some of the statements that
You-
were made in the
Let's just
second
ask the
round.
question.
Right, Mr.
Otherwise-
Schechter, you spoke about the disciplinary committee. You-
Not the disciplinary committees?
Right. The committee, is this a formal, is this committee that you mentioned in your presentation, is this a formal committee,
Yes.
like the Committee on Judicial, like the Commission on Judicial Conduct?
Well, it's part of the appellate division structure, these grievance committees.
Is
They're
this the
formal.
is this the committee that looks at regular lawyers' practice?
When a lawyer makes a mistake, an error, whether it's ineffective assistance of counsel or an unethical conduct, this is the committee that you end up in front of.
This is the same committee that handles complaints against prosecutors?
Yes. That's correct. The difference seems to be, though, and the problem that we have with it, is that when you have ineffective assistance of counsel, for example, the attorney gets to go with his attorney before the committee to rebut or to explain what happened. But the public, the person who made the complaint, like Mr. Deskovic, he doesn't get to participate in that proceeding. He doesn't even know that proceeding is going on, which is why, in many instances, as we're quoted here this morning, you don't even get a response that there's anything going on.
Okay, so this currently is the only committee that has any authority or power to review a complaint that would be
Yes.
brought against a prosecutor.
That's correct.
And regarding this committee, is there any official statutory or other oversight on this committee that could have have this committee accountable in any way?
I don't know the formal answer to that. I think if you lose in the grievance committee process, you can appeal, and you can go into court, and it can be looked at by the court system itself. Such instances are few and far between, but that's pretty much it. The grievance committee is where you go.
And how is a member of that committee appointed?
Ah, very interesting. A large number of the people who are on these committees seem to be appointed by the appellate division judges, sometimes by the chief administrative judge of the particular department. Now you might ask, what are the criteria for those appointments?
Is there any official criteria outlined?
None that I know of, except
And-
that you are a lawyer, you're well-known, you have a big firm, you have a big civil firm, you're known in the area. That basically is how
And
it's
is there
done.
any statute that says who makes these appointments?
Is there a statute?
Right, is there any law, any
I-
authority that
I believe there is such an authority, but it
conveys
rests within
the-
the appellate division. They have the guidelines for who they appoint and how they do it.
So it's a rule of the appellate division?
Yes, and it's totally
Okay.
ensconced within the judiciary. And that's one of the huge problems with these disciplinary committees. When I spoke to various people anecdotally, because no one will be quoted for the record,
And the rules of operation of these committees are set by any rules or regulations
well,
or statute
I
that we're
can't
aware of?
answer that. Nobody knows. It's a secret.
Now, doesn't the Court of Appeals also have the power to discipline attorneys?
The question was,
yeah.
after it gets out of the,
Okay.
after it gets out of the grievance committee, can it go higher? And I believe it can. It can go all the way through the court system up to the Court of Appeals, and you can be disciplined by them as well.
Okay.
Did I answer all your questions, Assemblyman Curry?
I think you did. I have a lot more, but we
Right.
don't have enough time today.
Excuse me. You're chomping at the bit. I've been in your seat before. The others are much calmer, but they're not, but they feel the same way about some of the things that you've said. So
Right.
why don't we get the questions, then we'll see
Sure.
how much time we have after that.
I have some questions for D.A. Scott McNamara.
McNamara.
McNamara. You mentioned in your statement that checks and balances exists. Do you think that they're adequate based on the serious transgressions that have been brought to light regarding actions of district attorneys around the state on more occasions than we should have?
I think that the current system we have in place could work better. I don't think we need a new commission. I think what we need to do is we need to shore up what we currently do. I think that the grievance committee, there are certain things that have been said here, I would agree. I think the people that are put on it, there could be better people put on it, but I think the procedure we have in place right now, and I say this reluctantly, but I do believe it.
You believe
When I
it's
was
adequate?
young, I believed being a lawyer was an honorable job. And right now, that isn't the public's perception. And I think the grievance committee across the board has a lot to do with that, because we've lowered the standard. And there are so many things that go on that we're not here to talk about, but lawyers who are suffering from dementia, representing people on felony cases. There's a lot going on. We need to raise the bar at the grievance level. We need to make the grievance committees that we have, they need to have people on it that are competent. The Justice Task Force is looking at all these things. There needs to be a general standard that's the same across the state. There shouldn't be 4 standards. There should be 1 standard. There should be punishment. The punishment should be made public. The censures that go out now, the private censures, that should be reported. Okay, if it's private, then you don't report the prosecutor's name, but report it so that the public knows that people are getting their hands slapped. You know, for example, when I fire somebody, and I have fired people for doing things wrong, I can't put that in the paper. They're lawyers. They're going to turn around and sue me. But there are so many things that go on that are unreported. So I don't believe we need a new system. I believe the system we have could work better. And I think that's where we should put our attention, because there's already a system in place. And, but there is no reporting. And I'll tell you something, I had to file a grievance against one of my assistants. And something that somebody else said is very true. I never got notification what happened. I got notification from that prosecutor because I have a rule in my office: if a grievance is filed against you, you must tell me. And if I find out that happened, you didn't tell me, you lose your job. So I found out that way. The grievance committee didn't send me a letter back, and I was the complainant. That needs to be fixed. There's many things in the current system that we could fix that would make the way it works, would not only make the system a lot better, but it would also respond to the concerns that I think really what's going on is that the public doesn't know. And because the public doesn't know, they presume it doesn't happen. If they knew what was going on and there was public accountability, I think everyone would feel better.
So you seem to be saying that it's not adequate.
I said, I think it's adequate, but it could be much better. That's what I'm saying.
You made a pretty terrific argument there that it's not adequate, District Attorney, because you cited
No, I was
lot-
being honest with you.
I appreciate that, but you cited a lot of reasons why it needs fixing, and that's why we have proposed this fix, which would take care of most of those issues that you raised, that I'm sure as a district attorney, there are colleagues who would agree with you that your perception of what's wrong with the system is real. And that's what we think here too. You commented on what is, I believe, the feelings among the district attorney who might be in opposition to this bill. You stated that we have rights, and I just want to add, in response to that, that this proposal, this law, if it should be, this bill, if it should be enacted into law, will not transgress on or take away any rights currently enjoyed by current district attorneys. There's no provision in our legislation that would impinge on the rights that you currently have. And we can understand that there will be opposition, but we stand quite ready to work with district attorneys who acknowledge that we have an imperfect system and that this part of the system is so important. In this, district attorneys have so much power over life, liberty, that we do need to have a system of checks and balances that will serve the purpose of renewing trust in our criminal justice system, because that's a part of the problem. And no part of our criminal justice system has a right to or should be left to police itself, especially in matters of misconduct.
But we don't police ourselves right now, sir. We are policed by
To a great
the grievance
extent you
committee.
do. To a great extent you do, because where complaints are not made, and part of the reason complaints don't come about that can be handled is because the whole process through which complaints can be made, it's not clear, and this commission would provide that kind of mechanism.
Can I just ask, after hearing your testimony, sir, are you a lawyer?
Emily? Me?
Yes.
Yes.
Good. I just wanted to ask, how do you currently handle incidents of perceived prosecutorial misconduct?
Of perceived
How do you handle the
Well,
incidents that occur, or how do you deal with them so that we can see how the system works? Because the system isn't broke, then we shouldn't fix it. But we want to find out from the defense bar, I think, that are here.
Well, then
I
I
just wanted to hear
might
from
not
you
be the
about it.
best person to speak because I'm not a staff attorney at the
Okay.
Innocence Project. I am in the policy
So
department.
maybe one of the
from
others can
policy-
address that issue.
As I understand the question, if there's perceived prosecutorial misconduct, how is it handled? In different places in the state of New York, different approaches are taken. Some are informal. For example, in upstate New York, where the prosecutor's offices are small and the number of attorneys practicing before them, everyone knows each other, when there's prosecutorial misconduct, the attorneys, or maybe the head of the local bar association, goes to see the district attorney. And in upstate New York, you can get in to see a district attorney. Fortunately, that's a good thing. And so there's an attempt at rapprochement, if not an attempt to solve the problem. Sometimes the district attorney's office is very hostile, and that will not work. So if you can't get the district attorney to meet and consider the problem and change it, then the next step is, and some attorneys do this and some don't, is to write a letter. When you write a letter to the district attorney's office, you are saying to the district attorney, okay, we're on record now. No more oral conversations. I'm telling you this prosecutor is engaging in misconduct. Then you wait to see what happens. Some district attorneys will have their assistants meet with you, and then sometimes what you find is that that particular prosecutor, A, is transferred to a different bureau, 2, taken off what they're doing, 3, quote, leaves the office, unquote, and goes elsewhere. Or the prosecutor continues in their current position, and you find out at the first of the year they've been promoted to a section head position. The next thing you can do after that is to go file with the grievance committee. To do that, you have to first consult your client and understand the client's wishes have to be taken into consideration, that the client comes first. You then file with the grievance committee the nature of your objection. When the New York State Association of Criminal Defense Lawyers filed its complaint against Mr. Taylor of Ontario County, it was an extensive brief that listed specifically the court cases, what he had done, and had exhibits attached. Then you wait. And the answer to that is you may wait forever. We still have no response, almost 2 years later, what is going on with Mr. Taylor. We know he's still working. He's still in the DA's office. He's still handling cases. That's the short answer to the question.